So then why did you go into the Hobby Lobby?
I would like to say that I didn't think the Hobby Lobby was a place that children would frequent. I thought it was just there's a craft store. I'm a person who enjoys art.
So do you deny walking around the store with your hands in your pocket?
No, I don't. I had my hands in my pockets.
Okay. Were you yourself? Were you touching yourself at any time?
I was not.
Ladies and gentlemen, Mandalorians, we are about to see something that can only be defined as insane. We are about to see the parole revocation journey for a serial offender, someone who was convicted twice for essay of a minor and has countless arrests for exposure and other such offenses like driving around, doing the thing, and even wall out on special parole after he had gotten released for soliciting a 13-year-old, asking her if she wanted to make a quick 20 bucks. Now, that's just the half of it. We haven't even gotten into what he did at the Hobby Lobby yet. But the bottom line is that we are looking at a man that whenever he is out, he is committing offenses. He is a serial offender, a chomo, a dangerous man. Yet time and time again, he is given slap on the wrist sentence after slap on the wrist sentence. There is so much information, news articles, arrest reports that it will blow your mind. I mean, I want to point out that he was arrested for SAing a 13-year-old. And while out on bond, he was arrested for public lewd acts. And yet he still only received about a year sentence for that. To get out and then guess what? Essay someone else again. You can't make this up. But we're about to watch his parole revocation journey, which means he was already paroled. We didn't cover that parole hearing, but he was immediately revoked. Revoked for soliciting a 13-year-old girl. We're about to watch that revocation hearing. Now, buckle up because this is insane.
Charge 1, obedience to the law. On March 13th, 2025, you and a registered sex offender, were driving around smoking marijuana in his black pickup truck. You rolled down the passenger side window and asked a minor, 13-year-old female, do you want to make $20? The father of the minor female observed the vehicle drive past his residence, and he notified Milford Police. Milford Police was able to identify the vehicle based off of video surveillance. Milford Police contacted Mr. Uberti, who stated that you were the passenger in the vehicle. Milford Police conducted a Department of Corrections check, which indicated you are a registered sex offender within the state of Connecticut. On March 20th, 2025, and March 25th, 2025, Milford Police left their business card at your residence with instructions for you to contact them. On March 25, 2025, you contacted Milford Police and stated that you had no desire to speak with police. A warrant was applied by Milford Police Department based on the criminal behavior described above. A judge signed off on the warrant on March 28, 2025. Due to engaging this behavior, or this criminal act, you were arrested on April 1st, 2025 by Milford Police Department for risk of injury to a child and breach of peace second. A $50,000 bond was placed on you. Your arraignment was held at Milford Superior Court on April 2nd, 2025 under docket ending in 475. A bond of $150,000 was placed on you with the next court date of May 15th, 2025. Charge 2, drugs. On or about February 19th, 2025, you used. The state has filed an addendum to Exhibit A, which states on June 5th, 2025, Mr. Derosa was convicted of breach of peace second. He was sentenced to 30 days jail. The charge, risk of injury, was nollied under docket ending in 475. Counsel, did you receive the notice of parole violation report, and the other documents that I just marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, letter of support from mother. Defense Exhibit number 2, letter of support from girlfriend, Lauren. And Defense Exhibit number 3, letter of support from grandmother, Sharon. Today we have no witnesses, and I just marked Exhibits 1 through 3 as letters of support from both mother, girlfriend, and grandmother, which were reviewed prior to today's hearing. It is now the defense opportunity to present evidence, speak to any of the evidence submitted. Counsel?
Yes, there are two women that I had indicated I had intended to call, his grandmother Cheryl and his mother Dorothy. I believe they received the link. Lisa spoke to his mother this morning, and I would ask that they be allowed to be heard.
Is there testimony in regards to anything regarding the charges or anything further than what they said in their statements?
The testimony, I guess, is fairly depicted as the second stage of this proceeding, not necessarily the guilt or responsibility part. It's more of the punishment aspect of the hearing.
So again, they were very detailed in their letters of support. Is there anything in addition they would like to provide?
Yes, there is.
Yes.
But it doesn't go to the, as I said, it doesn't go to the responsibility or guilt portion. It goes to the second part.
Okay. I'm just going to take a quick recess before I admit or deny their testimony. Okay.
Certainly. Thank you.
During the recess, I will let you know we are still live streaming to the public, but the officer is not going to be proceeding with the case until she returns.
Do you have the ability to put us in a separate room?
I do not.
Okay.
I can mute each participant, but I'm not able to connect the two of you.
Okay. Thank you.
I'll just ask anyway, what about the letter from the elder and the evidence of me attending AA and all that?
I didn't get to that. I didn't get to that yet. I have that. I just got it.
Fair enough. Fair enough. It wasn't listed as evidence. That's the only reason I
I
asked.
just got it a few minutes ago. Do you intend upon saying anything?
I do. I have it written down.
Okay. I would imagine that your testimony goes to the second part as well, not the guilt part, right?
That's correct.
Just so you know, it's my intention. You admitted to the cocaine use. You pled guilty. It's my intention to admit to the conduct. Let's go to the second stage. You fair with it? I mean, we're not going to. You agree with that?
Yeah.
Okay. I just want to make sure. I should have. I don't know if I said that in our conversation before.
You did. You did.
I actually received that email from your counselor while we were on the Zoom, so I had no opportunity to share it with him. Yeah.
Interesting.
Would have been nice to have had it earlier, but.
Well, I had a copy of it anyway, just in case you didn't receive it.
And you're talking about from Ortega? Chaplain
Yes.
Ortega? Okay.
Yes.
Okay, we are back on record. Being that grandmother and mother are regarding the second portion of this hearing, we're going to move forward with the first part of this hearing. So, counsel, it is now your opportunity to speak to any of the evidence at this time.
Thank you. Upon consultation with my client, both on a different date and confirming this morning, we are admitting to the 4 charges that are included within the parole violation report.
Thank you. Anything further?
Not in regards to the first stage, no.
Thank you very much. Regarding charge 1, obedience to the law, I make a finding based on Mr. Derosa's conviction, as well as state's exhibits A, D, and F. On charge 2, drugs, I make a finding based on state's exhibits A, D, G, H, and I. On charge 3, no contact with minors, I make a finding based on state's exhibits A, D, F, and J. And on charge 4, problem sexual behavior treatment, I make a finding based on state's exhibits A, D, F, J, and K. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, Your Honor, I apologize. That's a habit.
It's okay.
My client has prepared a document he wishes to read to you.
Absolutely. Mr.
Thank
Rosa?
you.
So I'll be honest with you. I admit I made both a mistake and a serious error in judgment. I should never have engaged in the behavior that led to my rearrest. So at this point, the question becomes, why will this time be different for me? The simple answer to that is that I have woken up. What that means is that I'm committed to being different. I lost sight of everything when I began getting high again. However, being back incarcerated this time has been exponentially more difficult than ever before. I can honestly say that I understand the consequences of my actions. I'm dedicated to changing my behaviors. What that means is that I'm committed to taking care of my mental health through therapy and medication, as well as my addictions through programs and NA. And most of all, I'm dedicated to working to change my deviant behavior by continuing to work with CTPSB and through possible outside counseling as well, if it's believed to be necessary to help me. I know I've come before you appearing to be a slow learner. However, I have learned. I will be better. I was a model parolee until I began to use, and I can and will be a model parolee again. If you allow me mercy, you will truly never see me again.
Thank you. Counsel?
Thank you. So I do know that his mother and his grandmother had brief statements to make. I would ask that you grant permission to allow them to do that.
Typically in these hearings, we don't normally have character witnesses. So again, it's beyond their statements of their letters of support that they wish to make further statements.
I have not spoken to his grandmother to that extent. His mother did say that her comments are beyond what she had included in her statement.
Okay. And before doing that, counsel, what is Mr. Derosa's release plan?
His release plan is part of what his mother wants to address. His intention is to live with her. They have agreed to a contract between the two of them, which includes mental health therapy, NA, and she, for lack of a better word, has a zero tolerance policy with him. She will describe at how they really weren't prepared the first time he was released. They did not know what to expect. There were a lot of different issues going on with him that they were just not equipped to deal with. And they're both in a much better position now. What is significant is that, in my experience, the best chance of rehabilitation or someone who perhaps doesn't recidivate is a buy-in, and a buy-in not from just the client, a buy-in from the family, a buy-in from providers, a buy-in from extended family, a buy-in from the people that you reside with. And it seems genuine that they both are willing to do that. From what his mother relayed to me, there was a slip up in the past. She was the first one to call parole. So in the federal court, there's something called a third-party custodian. I'm not sure if you're familiar with that term. What federal judges do, in addition to releasing someone on bond, is they typically have a third-party custodian, which is someone who is essentially acts like a warden and is required to report misconduct. I know that's not necessarily something that's within the parameters of the parole board, but in practice, that's what Ms. Dickinson is prepared to do. She's prepared to be that tough love person, as she has in the past. I think that she realizes that the combination between misbehavior, mental health, and substance abuse was a recipe for disaster. I think she's a little better equipped now to deal with that. What is significant is when you consider the fact that in imposing a sentence based upon criminal conduct, by Connecticut Constitution, the court must consider the position of the victim. So I think it's not insignificant that initially facing a charge of risk of injury and breach of peace, my client admitted to the conduct that led to the breach of peace. It's not insignificant that they dropped the risk of injury. And I say that in the context of, number one, the allegations, and number two, his prior history. I also think it's significant that the prosecutor believed that a 30-day sentence was appropriate. Presumably, the victim was on board with it. I have no information to suggest that they weren't. And finally, that a judge accepted that as an appropriate punishment. So when you consider the fact that his punishment was 30-day sentence from an initial incarceration date on this offense of March 13th, he will have served 100 days on top of that sentence, which I do not think is insignificant. And I think that additional sanction, coupled with number one, his desire, number two, his mother's desire to essentially be that unofficial warden, and thirdly, Connection's willingness at the end of their report to accept him back, He was there for a year, was discharged unsuccessfully due to this arrest and other violations of their rules that he signed. But I think their willingness to accept him back does show that there is an opportunity here. No one can predict the future. I certainly, neither me nor my client can guarantee the future, but certainly there is a groundwork that's present to make that possible. That lack of recidivism, perhaps a path towards treatment. I know that someone looking at this on paper would say there are red flags, there are risk factors, but I think there are also protections in place that would support the possibility, the strong possibility that he can be successful. And I think that his statements, I'm hoping you can appreciate the sincerity and at least his tone. It's one thing for someone to read from a script that they wrote. It's another thing. It seemed like it was heartfelt. I don't know that his mother would have anything in addition to what I added as part of her statements to me. So to the extent that you feel that's not appropriate, I don't think that we've lost anything in our presentation.
Thank you. So I understand that your release plan is to go to your mother's home, and her name is Derosa.
That's correct.
And what is her address? So, counsel, being that you said there's pretty much after your statement here today, there's nothing further to state regarding the release plan. I understand that your mother will be acting as a quote unquote unofficial warden to report parole or any misconducts. So, with that stated, I don't really see that there's an appropriate need for Ms. Dickinson to make a statement or testify here today. And it sounds like grandmother also will be a support to you as well. Okay. So I'm just going to take a moment, unless there's anything further you would like to add, counsel.
I'm just reviewing an email she sent me, which is what the supplemental information. And she said that, if I can just read it, it's only 4 lines.
Absolutely. Yep.
That she spoke to Dylan in regard to a contract between he and her, and that they will find a psychiatrist. She'll monitor his medication, as well as monitoring his prescribed medications. And it is important to note that his mother is a registered nurse. So I just wanted to add that.
Thank you so much. And regards to, it sounds like you're going to be focusing on, your mental health, your sobriety. Any aspects for employment, or are you going to work on your mental health?
Employment is a major factor as well. I had several potential job opportunities shortly before I was arrested. Unfortunately, I was not able to engage in that employment. I was employed for almost the entire time I was home up until right before I was arrested. And I had, like I said, a couple of job opportunities that were coming up right before I did go back to jail. So I don't foresee too much difficulty in reobtaining employment.
Okay. And are there any current offers that you would like me to make note for the board?
Unfortunately, I can't truly say that I have an offer in front of me at the moment.
Understood. Thank you. So I'm going to just take a moment before I announce my recommendation.
Thank you.
And just for the record, it's up to PCS, Parole and Community Services, when it comes to your housing and placement. So just to be very clear on that. So they obviously have to approve your mother and go through that whole process. Okay, Mr. Derosa, I see that you were discharged to special parole in January 2024. Since being discharged, you were in the community for approximately 1 year prior to your remand and your arrest. In that time frame, you did receive 2 misconducts. There were 2 positive drug uses. And then you did have this arrest that led to a 30-day conviction.
Yes.
Based off of everything that was stated today, this is your first parole violation since being discharged to special parole. I recommend revoke and re-parole on September 2nd, 2025, which is an approximate 5-month sanction with the following conditions: no contact with victims MW and JK, a general no contact with Edward Uberti and CA, also the address of mental health treatment, no contact with minors without the express permission of your parole officer, and problem sexual behavior treatment. My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board. And your board review is scheduled on July 31st, 2025, which is next Thursday. So my recommendation is a 5-month sanction with all of those conditions, okay? The board, they can accept or adopt that recommendation. They can lower that recommendation, or they can exceed that recommendation, being that you're on supervision until January 2034. If the board does not agree with that recommendation, then another hearing will take place, which is called a supplemental hearing, and they would you would appear before the board, and they would explain to you why they would want to seek further incarceration. Okay.
Okay, thank you.
So again, your board review is scheduled for next Thursday, July 31st, and you will receive everything in writing.
Thank you.
Thank you for your
Okay.
consideration.
Thank you very much.
So the board is going to have to review this, and we'll right now watch what the board does, what their decision is, to see if they thought that 5 months is an appropriate sanction. Keep in mind, he was out for just 1 year. In that year, he had 2 dirties, he had 2 misconducts, and he had an actual conviction. And I just want to point out the pathetic, DA and judge. They have a repeat offender, someone who is a serial offender, and he's out on special parole and he solicits a minor, and they drop the charges. They drop it to a 30-day in jail. And this is the thing. This is I'm so happy to show this case to all of you, because it just shows how the data is skewed, how the facts and reality of offenders and chomos and reoffenders, how all of it is muddied, so that it is so that on paper it doesn't even show that this monster solicited a 20-year-old, because they dropped the charges. They made it a breach of peace instead of what it was. And then they go on to argue, obviously, it couldn't have been that bad because it was only 30 days. And really, this is it. This is it. It's when you have weak district attorneys, or you could, maybe it's several things. Maybe they're lazy. Maybe they figured, well, he's on special parole. The parole board will handle it. So let's not go to trial. Let's just let the parole board handle it. And this is what happens. Now, anyways, let's go see the wisdom of the board and how they would like to handle this situation, if they would add 5 months or keep it as is.
Good morning, my name is Paul Officer Saunders. Today is Thursday, July 31st, 2025. Board members, please take your names for the record.
Joy Chance.
Michael.
Deborah Smith Palmieri.
This is a final revocation review for Derosa, MA number 395251. I recommend revoke and re-parole on September 2nd, 2025, which is an approximate 5-month sanction with the following conditions: no contact with victims MW and JK, a general no contact with Edward Birdie, Christopher Armstrong, and the address of 135 Seaflower Road located in Milford, Connecticut, mental health treatment, no contact with minors without the express permission of your parole officer, and problem sexual behavior treatment. Does the board accept or reject this recommendation?
So we have reviewed the findings and recommendations, and we just like to make a brief statement before we accept. So as a panel member, I had concerns about Mr. Derosa. But after reviewing the statement made by his mother, who is going to be his sponsor, I have decided that I accept the support and the release plan based on it being more structured, but that Mr. Derosa understands that that's the reason why we're going to accept your recommendation. Is there anything else anyone wants to add to that?
No, I agree with you, Ms. Chancellor. I shared the same concerns. I appreciate that, the more serious of the 2 charges were nollied. However, whether or not they were nollied is really not always relevant. And I too am in favor of the recommendation based on the information provided for his release plan and the statements made by the sponsor.
That behavior came back again, I'd be voting for rescission for
Supplemental, yes, yes,
I think we're all in agreement on that.
yes. So I approve and adopt them. I move to adopt the hearings examiner's recommendation. Do I have a second? All in favor? Aye. Motion carries. Aye.
This concludes the final indication review for Derosa, MA number 395251.
Okay, I mean, they agreed with the recommendation. It's going to be just 6 months or 5 months sanction. I'm sorry, if you can imagine, they actually said, "Well, because we see his mother is in support, this is good. This means he really only should get a 5-month sanction." Let's keep in mind in the articles, and I'll go through them with you eventually, the mother has been there, babying him and protecting him in all of his like charges. You could see him. She's brought up in many of the court documents. So clearly, she has been doing a horrible job at protecting the public from her son, who is this monster. But anyways, look, what do we know, right? We don't have PhDs. We're not in the Department of Corrections. We don't understand how any of this works. Clearly, a serial chomo, a serial pred who has not been able to stay out of trouble pretty much his entire life. There is no chance. I think, as Dr. Grande says, that if there is one thing for certain, it's that we will never see Mr. Derosa again.
Good morning, Mr. Derosa.
Good morning. Before we get started, is it possible for me to ask for a continuance? I'm having issues with my counsel.
Yeah, so the next available hearing will be October 27th, which is Monday.
Monday, okay. The issue was I originally declined a public defender as I believed I was going to have outside representation. However, that fell through at the last moment. So I do need to get back with the public defender's office so that I can have representation for this, if that's possible.
No problem. So what I'll do is I'll send them an email letting them know that you would like representation, and we will continue your hearing until October 27th. Okay?
Thank you so much.
Thank you.
Okay. Thank you.
Thank you, Peel Monroe.
28 days. 28 days is precisely how long he lasted until he was arrested. Arrested for following around little ones in a Hobby Lobby doing the thing. You can't make it up. This man clearly cannot help himself, yet the system continues to release him out into the public to create more victims. Now, we're about to watch this revocation hearing where they go over the details and where he gets another sanction. And believe me, it doesn't end here. The story, the saga, it keeps on going. But before we do, I think it will be helpful, in case I haven't done a proper job, just painting the picture of how what kind of serial offender he is. So we'll go through that now. If you don't want to hear it and you want to skip ahead to the revocation proceedings, there are timestamps in the description. But let's start with what Sir Richard compiled for us. Now, as you have here, this isn't even a full picture because this is really just like convictions and arrests. But you have in 2013, he has SA between someone of this age. Now, I would assume she's 13 because that has been the target age of all of his victims. He was released 5/28/2014. So he got a slap on the wrist. This was a full-on SA, by the way. This wasn't, it was SA. In 2016, he had public indecency, risk of injury to a minor. Public indecency got 5 months, 6 months, 6 months. And then in 2017, he had an aggravated SA first degree. So this is his second, right? And he was caught with a firearm. And he was given 90 months with 10 years special parole. While he was out, he receives 2 breaches of peace. One is for soliciting the minor, and 2, which was 9/30/2025, which we're about to see, is for when he's following someone or a little one in the store doing the thing, okay? And he only gets 6 months and 30 days. Now, these are actual sentences, okay? These are actual, which they drop the charges, but this doesn't even paint the full picture. What you have down here, we're going to go through the information, is absolutely insane. For example, as Sir Richard here has in how insane this is, I think I need to show with you like the articles, the actual articles, because that paints a little bit of a clearer picture. So hold on while I do this. So let's go back in time. So when he's 20 years old, he's accused of SAing a little one. This is back in 2011. They charged him with SAing a girl under the age of 16. I assume she's 13. Police Officers said that the department received a complaint of an essay that occurred on January 2010. The department investigation led to an arrest warrant for Dylan Derosa. Derosa is charged with first-degree essay and risk of injury to a minor. Police said that Derosa was familiar with the victim but declined to provide any additional information because of the nature of the crime. The arrest warrant says he was ordered to be sealed as it involved alleged essay. He was held on 20,000 bond or whatever. Now look at this. While he was out on bond, he gets indecent charges. So that crime took place. He was arrested in 2011, October 18, 2011. While he's on bond, he gets July 16, 2012, the indecent charge. This is what that is. Arrested for allegedly doing master debating in public while observing preteens. Police arrested Derosa, 21 now, after they received a complaint on July 11th around 6 p.m. From the mother of a girl who said a man in the vehicle was acting suspicious and appeared to be master debating. Derosa then allegedly drove down the street, turned around, and parked closer to the little ones. The woman who called the police then went to her room to see if the car had left. She allegedly observed Derosa without pants on, and he was, doing the thing. Derosa is charged with indecent exposure, public indecency, and 2 counts of risk of injury to a minor. At the time of the arrest, he was also found in possession of 23 grams of the devil's lettuce. This is while he's out, right, on bond already for the SA. So this occurred July 16 of 2012. Now they update it July 28th. Let's see, is this another one? Derosa, so this is in court. Derosa appeared nervous as he sat outside the courtroom with his mother Wednesday, waiting for his case to be called. Derosa was arrested in October for first-degree SA and is now facing additional charges for indecent exposure in public and 2 counts of risk of injury to a minor. The new charges from a complaint. Okay, this is now him going in court, right? And remember, he got a slap on the sentence. I think he gets like a year or something for this. Then when he gets out, he gets caught again, committing lewd acts. This is 2016. Milford police have charged and convicted. Right now, he's a convicted S offender with committing a lewd act in public. He's 24 years old now. He's arrested Tuesday night after police said he was master debating in a car in the area of Beach Avenue and Wall Street. According to police, Derosa rolled down his window and asked someone, "Hey, can you give me a hand with this?" Derosa left the scene, but police later found him and the witness and was able to identify him in the car. He was charged with public indecency and second-degree breach of peace. Now, why was he not, revoked or whatever? I don't know. It's all just gimmick. He was convicted, so he's already on the sex offender registry at this point. Well, we can go over in a second what exactly he got for this, but I don't think he. So this was March 2nd, 2016. Now, he got out, I guess, on bond because just 2 months later, May 27, he gets caught doing this in front of little ones, right? So clearly he hasn't learned his lesson yet. Now he's 25 years old. A 25-year-old man who served a year and a half in prison for the previous statutory SA has been arrested for allegedly doing the deed in front of a group of little ones. So he did a year and a half, right, for the first offense. Dylan Derosa was charged with risk of injury to a minor and breach of peace and public indecency and was released on $50,000 bond. He was arraigned June 21st, Superior Court. The incident occurred Tuesday, said Officer Joseph Dempsey. Derosa drove past the little ones and then returned, this time with the car door open. When the little ones saw him doing the deed, the eyewitness description and vehicle statement helped police to develop a suspect, the department said. In November 2012, Derosa was found guilty of felony SA charge and having with an little one. He was sentenced to 18 months. At that time, he was also found guilty of public indecency, misdemeanor, possession. Okay. So this is another charge. While he's out, he gets caught doing that again. You'd think they'd throw the book at him, right? But they don't. And this is not it. He go fast forward to July, where he's still out, July of 2016, right? So this is 2 months later. He's found with a firearm. But that's not all. He's not only found with the firearm, he SAs another person. So a local man with a felony conviction of SA was to appear after allegedly found an altered gun at home. He is barred from possessing firearms for his criminal record. Dempsey told police that he received a report from Derosa to have a gun and got a search warrant at the residence. Derosa was charged with criminal possession of a firearm or removing marks of the firearm and was held for the court appearance. State records show that Derosa is a registered sex offender who pled guilty in November of 2012 to second-degree SA. The charges indicate that the victim was between 13 and 16, and that Derosa, with record indicated what happened in 2010. So they don't even talk. Wait a minute. Here it is for the for the sexual assault charge. Derosa was sentenced to 8 years in. So they don't even talk about this, but he also got another SA charge. State records showed Derosa is a registered offender who pled guilty in November of 2012 to second-degree SA. So he ends up getting sentenced. Derosa was sentenced to 8 years in prison, suspended after 18 months, 10 years. Well, hold on a second. Derosa pled guilty to violating his probation in 2014. It's not clear whether he received any jail time, right? So that's the gimmick. So he owed 10 years. And so I'm a little, okay, there's a little confusion here, but I not just on my part in showing it with the articles. Let me see if I can pull up clarity. I just want to point out that with this gun charge, he also SA'd someone. So let's go just pull it up here. He's arrested on 5/26/2016 for risk of injury, sentenced to 5 years jail, 6 months respectively. He pled guilty to felony cross, was fined, alteration of and SA. See, so when he had the firearm possession, he also had SA, and here he's sentenced to 5 years jail and 1 year jail, 9 and 90 months jail, and special parole 10 years. Respectively in 2017. He was released in 2014, solicited the minor. We saw that revocation hearing, got a 5-month sanction, and now he's back for this next offense. And if you were just even a little bit confused, in his record where it talks about him being an S offender, it shows here. I could share this actually. You could see it's not 1, but it's 2. There's 2013. Where he's convicted for this, and then there's 2017 where he's convicted for aggravated SA first degree. So a repeat serial offender is given really just a minor sentence. They could have gone him 5 years simply for the gun, for having gone without a permit, and then even more time for altering it. He's backing all this time. He's a serial offender, and he gets out on parole. Just years into his sentence, 2024. So I think he ends up serving, I don't know, 5 years of it. I'm not great at math. Maybe 6 years of it, but he's out and violating again. Anyways, I know this wasn't a great representation, but I hope that it's just, what am I supposed? It's crazy when you got to go through this information. So here it is. This is we're gonna go. Let's go see the revocation hearing, his attorney, and the excuses that they're gonna make. It's gonna blow your mind. You're going to want to scream. You're gonna want to scream. Let's jump in.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On September 30th, 2025, at approximately 2:44 p.m., East Haven Police Department was dispatched to Hobby Lobby due to a female complaint that was inside Hobby Lobby. The female complainant stated that she saw a male, later identified as you, with a beard, wearing a Chili's t-shirt, white and black checkered pants, and black sneakers inside the store master. The female complainant stated that you were following women around the store, and at one point she observed you to have an erection with your hand in your pocket. She stated she started to videotape you and follow you around the store. The complainant told East Haven Police Department that you were touching your penis and that you definitely had an erection. She stated that you did not remove your penis from your pants and your penis was inside your pants the entire time. The complainant told East Haven Police that she was extremely uncomfortable, disgusted, violated, and annoyed due to your sexual actions. East Haven Police Department officers went to Chili's. You were at work and showed a photograph of the male in question from Hobby Lobby. You were identified by your coworkers. Due to engaging in a criminal act, East Haven Police Department placed you under arrest for breach of peace and issued a $75,000 bond with an arraignment date of October 1st, 2025. Your arraignment was held at New Haven Superior Court on October 1st, 2025, under docket ending in 328. And the bond was set for $2,500 with the next court date of October 22nd, 2025. Charge 2, halfway house placement. On September 2nd, 2025, you were placed at Walter Brooks Halfway House. On the same date, you signed your halfway house agreement. On September 30th, 2025, you signed out of Walter Brooks to go to work at Chili's in East Haven from 12:30 p.m. to 10:30 p.m. At 2:44 p.m., you were arrested by East Haven Police Department for breach of peace for walking around Hobby Lobby with your hands in your pockets and having an erection. You did not receive verbal or written permission from your parole officer or the halfway house staff to deviate from your past, and you were unaccountable in the community. Charge 3, problem sexual behavior treatment. On September 30th, 2025, East Haven Police Department was dispatched to Hobby Lobby. The female complainant stated that you were following women around the store, and at one point she observed you to have an erection with your hand in your pocket. The complainant stated that she started to videotape you and follow you around the store. The complainant told East Haven Police Department that you were touching your penis and that you definitely had an erection. She stated that you did not remove your penis from your pants and your penis was inside your pants the entire time. She told East Haven Police that she felt extremely uncomfortable, disgusted, violated, and annoyed due to your sexual action. You were subsequently arrested for breach of peace by East Haven Police Department, and a $75,000 bond was placed on you. The state has filed the following exhibits. Exhibit A, parole violation report. Exhibit B, parole violation notice. Exhibit C, parole rights. Exhibit D, conditions of parole. Exhibit E, remand custody order. Exhibit F, East Haven Police Department arrest report ending in 398. Exhibit G, Connecticut or CTPSB treatment agreement. Exhibit H, CTPSB unsuccessful discharge letter. Exhibit I, Walter Brooks client sign in and sign out sheet. And Exhibit J, halfway house agreement. The state filed an addendum to Exhibit A, which states on December 3rd, 2025, Mr. Derosa was convicted of breach of peace second. He was sentenced to 6 months jail under docket ending in 328. Counsel, did you receive the notice of parole violation? Parole violation report and other documents that were just marked for identification purposes?
I did.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses. It is now the defense opportunity to present evidence, speak to any of the evidence submitted. Counsel?
Yes, I'm sorry, I was reviewing some stuff. But Mr. Derosa, we did, okay. I just have some brief comments regarding charge number 1 under obedience to the law, because the remaining 2 technical violations all have to do with these September 30th incident. So Dylan, this case that went to court, you hired a private attorney, correct?
That's correct.
Okay, and you had discussions with your private attorney regarding asking for a trial on this charge, correct?
That's correct.
Okay, and it's my understanding that you relayed that information to your attorney. Your attorney spoke to one of the prosecutors in court, and you were told in order to put you on the trial list, you'd probably be sitting approximately a year before you went to trial. Is that correct or not correct?
That is absolutely correct.
Okay, so the breach of peace, hopefully your attorney did tell you the max sentence is 6 months, correct?
That's correct as well.
Okay, so in order to have your quote unquote day in court, you'd be sitting in jail for a year before you even got a trial. Okay, and the reason why you'd be sitting in jail is because of the status you have of being on parole.
Yes.
Okay, and once you're violated, you have a different status, because if you were not on parole, you would have been able to post a $2,500 bond and ask for a trial. Even if it took a year, 2 years, you'd be out in the community. But that does not apply to you because of your parole status, correct?
That's correct, yes.
Okay, so when you entered your plea in court on December 3rd of 2025, was it a straight guilty plea? Did you plead under the Alford Doctrine? How did you plead in court?
We pled under the Alford Doctrine. The state's attorney made it very clear that I was to either plead to the 6 months that he was offering or that I was going to sit for that year. So my attorney made it clear to me that my best option was to plead under the Alford doctrine, even though I maintained my innocence the entire time, because I would just sit for less time that way.
Okay, and the Alford doctrine, we all know you don't agree with everything that was in the police report, but in your particular situation, you needed to wait approximately a year before you had your day in court, correct?
Correct. Correct.
Okay. And the reason why I need to make those comments regarding Mr. Derosa, a couple of things. We're not disputing that there was a disposition in court, but what's important to note, at the revocation hearing, we're at the preponderance of evidence. Preliminary hearing, I know I'm not trying to tell you that you don't know this. We got preliminary hearing, probable cause, we have revocation, preponderance of the evidence, so we have criminal court, the highest level of proof beyond a reasonable doubt. And so I speak to my client and he gives me some background about what happens in court. Under obedience to the law charge here, in the report, it indicates the women, he was following women around this Hobby Lobby. And there's only one alleged victim that came forward. And she allegedly videotaped Mr. Derosa, and the police were notified. And obviously there's a report. Exhibit F, if I may bring that to your attention, on page 204. Paragraph 1, where the individual shows the police officer the video that she took. The last sentence of paragraph 1, which I've highlighted and I've astonished, it should be noted, at no time did I see the male motioning his hand within his pocket from the video she showed me. In court, to get a conviction, proof beyond a reasonable doubt, there's no way that's proof beyond a reasonable doubt. If you have a police officer coming in and say, it should be noted at no time that the male motioned his hand within his pocket from the video, we'll leave her name out, showed me. Next paragraph, the police followed up and went to Hobby Lobby, the IT people there, and indicated there's an individual who worked, who ran the cameras there. There are a lot of blind spots within the store, but from the video footage, he observed the male walking around with his hand in his pocket, which that's not a crime. He observed hand motion as you're walking, he hands him, but could not say for sure if it was from him masturbating or from him walking. Once again, it's important to note, proof beyond a reasonable doubt. You got a police officer saying from the video he can't see any of that. Not even at no time did I see the male motioning his hand. So the police officer, which we're supposed to give credibility to, that they're trained in observing things of that nature, and the cameras don't show that. The issue with my client getting 6 months is he'd be sitting for a year. So it's the lesser of the two evils. I understand here it's preponderance. I understand you have a plea in court, but I needed to give you some background to show how we got to that. Because if my client did not have parole status, where does that do not release, all day long, this is a tribal case where you have a police officer coming in and you have the IT person coming from the place that cannot say, not even with 50% certainty. The police officer says at no time did I see him motioning his hand, and the IT guy says I saw him walking with his hand in his pocket. That is not proof beyond a reasonable doubt in any courtroom in the state of Connecticut. Maybe with those comments, I understand use a different standard here. I know you're going to make a finding on that, but it's important to note to put all this into context of how we got to the chart. Thank you.
Thank you. We'll take a moment for announcement finding. On charge 1, obedience to the law, I make a finding based on Mr. Derosa's conviction as well as state's exhibits A, D, and F. Charge 2, halfway house placement, I make a no finding as the state failed to provide sufficient evidence to prove Mr. Derosa's actions meets elements of this charge. And charge 3, problem sexual behavior treatment, I make a finding based on Mr. Derosa's conviction as well as state's exhibits A, D, F, G, H, and I. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, on behalf of Mr. Derosa, my client is 34 years old. When he, on his previous release, he was placed at the Project Moore halfway house until he was remanded. Also, prior to that, he did successfully complete the Connection Inc. residential problem and sexual behavior program, the January Center in Uncasville, and he was all then sponsored by his mother in Milford. As far as his education, he did receive 27 credits in business administration through a Pell Grant at Snapscott Community College. He was working at the time, as indicated. Apparently, he had his allegation was he had his work shirt on when he's walking around the store. And previous to that, he had a full-time job as a cook at the Hair of the Dog restaurant in Milford for approximately a year. So when he's out in the community, he is working. He does participate in treatment. It looks like September 2025, he did the Connection, the CTPSP program. He participated in 2 prior treatment episodes, 2014 to 2016, and then from April of 24 to April of 2025. He did report to us. He participated in the New Thoughts program while at the Walter Brooks House, and also began individual psychotherapy at the Cornell Scott Health Center in New Haven. Supposed to start IOP, which he was going to do, but then he was remanded, and he did receive medication management from Dr. Berkowitz at Liberty Integrated Behavioral Health in New Britain. Also voluntarily enrolled in the Tier 4 program while in the facility. He did begin that last month. I did speak to his mother. She is a viable sponsor. She's been a sponsor in the past. I provided you with her name and her phone number and address. He does wish to finish the business administration program at this community college. He indicated he did have a program for that. And he also has an opportunity with a friend of his doing construction and demolition in New Haven if the job as a cook is not available to him. And he's amenable to any treatment recommendation. He has been doing treatment. So and has completed it. So got a job, was doing treatment, and was at the halfway house. Dylan, anything you want to add? We're past stage 1, not about the charges, about your background, but what you want to do as far as treatment, job when you get off. You think I left anything out? Anything you want to add?
Not that you left anything out. I'd just like to clarify. I was under no obligation to enter Tier 4. However, I made you a promise when I was here last time that I was going to pursue drug treatment, and I did not allow this remand to derail me. I voluntarily entered the Tier 4 program to continue that. I was recommended to do Tier 2. I didn't think that was going to be strong enough. I know that I need help for my drug issues, so I've chosen to take the steps to do that. I will continue psychotherapy. I do as much as I can here. We all know what's available to us in the DOC. I avail myself as much as I can of that psychotherapy here. I plan to continue all of that when I go home. I was also limited by my access to that by being in the halfway house. It didn't give me as much freedom to attend as much as I would like to. If and when I am sponsored out home, I plan to continue in the upteenth of my abilities to everything possible. And I will adhere to all drug treatment and any other recommendations you have, psychotherapy. And I plan to, try to give back as well, because that's one thing they teach us in this program is that we can only keep what we have by giving it away. So by assisting others in their recovery, I'll maintain my own. And that's really all I have to say.
All right. Thank you for your comments.
Absolutely. Anything
No, and you actually beat me to it. I know you but mention it. He was here previously for it was a minor misdemeanor. Like I said, he's doing what he can given the circumstance while he's in the facility doing treatment. When he's out, he's doing treatment. He did obtain work. Working the last time he was here also. So he's trying, no doubt about that. Thank you.
Thank you. I'm going to take a moment before I announce my recommendation. So Derosa, you were discharged to special parole back in January of 2024. Since being discharged, you do have one prior violation as stated today, which was a criminal violation. This is your second violation. You were only in the community for approximately 28 days prior to this new arrest. Taking into account the nature of this arrest as well as your previous violation, I recommend revoke and reparole on September 30th, 2026, which is an approximate 12-month sanction with the following conditions. no contact with victims MW and JK, a journal no contact with Edward Uberti and CA, as well as the address of 135 mental health treatment, no contact with minors without the express permission of your parole officer, and problem sexual behavior treatment. My findings and recommendations will be given to the board, and your board review is scheduled on January 15th, 2026, which is next Thursday. So my recommendation is a 1-year sanction. The board can lower that recommendation. They can adopt that recommendation, or they can exceed that recommendation, being that you remain on supervision until January of 2034. But whatever the board decides, you will receive in writing. Okay?
All right, thank you.
I'm sorry, the pre-parole date is
9/30/2026.
9/30/2026. So Dylan, it's going to the board on January 15th. You and I will get something in writing about 7 to 10 days afterwards. If there's an issue with the recommended re-parole date, I'll set up a legal call with you and go over the next step with you.
Okay, thank you.
All right, good luck to you.
Thank you.
A 12-month sanction, you can't make it up. A 12-month sanction is what she recommends to the board. Now, let's go see what the board says. But I just, again, want to point out the insanity of this, the pathetic DA. You would think that they'd want to throw a repeat serial offender, someone who is continuously creating more victims, new victims in their community. But what do? They bring it down to a breach of peace. They give him 6 months jail. So the first time he solicits a 13-year-old, they give him 30 days, bring it down to breach of peace. And then the next time he's out, they give him another breach of peace, 6 months. They are skewing the facts by even calling it a breach of peace and not what he was initially charged for. And they're giving him time that is being served anyways concurrent, with his existing sentence. So he gets it's like a 2-for-1. It's like it's a get out of jail free card. How are you not enraged as a district attorney to say, get out of my community, get back in prison, stop creating victims in my community? Remember that these positions, they're elected positions. People elect the DAs into office, but they don't understand it. We don't understand that we literally have evil, which is the DA, evil, that allows these monsters to come out and reoffend. Or if you want to play devil's advocate, they just don't want to clog up the system. Let's see what parole will decide. Well, in this case, parole only said 1 year. Anyways, let's see what the board says. Let's see how they want to handle this.
My name is Parole Officer Saunders. Today is Thursday, January 15th, 2026. Board members, please state your names for the record.
Panel Member Barry.
Panel Member Rodriguez.
Robert Sadauskas.
Application for Dylan Derosa, inmate number 39525. I recommend revoke and re-parole on September 30th, 2026, which is my approximate 12-month sanction with the following conditions. No contact with victims NW and JK. A journal no contact with mental health treatment. No contact with minors without the expected of your parole officer. Problem sexual behavior treatment. Does the board accept or reject this recommendation?
Oh, this is one that I would like to talk about, please. So just for the record, I did inquire with our supervising psychologist about Mr. Derosa's case because his level of sexual deviancy. So when I reviewed this file, lots of things popped out, and I really was concerned about the nature of his new violation. And despite his being in treatment, and he's rated at a high risk to recidivate with a new sex offense, and his inability to control himself or utilize the tools that he's gained in treatment, and he's been in treatment for a very, very long time. I really do believe that I still have questions to ask him, one, but I do believe that this file at least needs to be discussed, the behaviors. So I'm going to ask, I would like a supplemental hearing on this one. So what are your thoughts?
I was okay with the officer's recommendation and sanctions. I mean, I hear what you're saying. It was very, he's had treatment before. It's politically challenging. But I did have it, except I don't know where my other colleague is on this.
Okay. Mrs. Sadowski?
Yeah, so a couple of things that stood out to me, I also was troubled by reading all this, is that he was only out for 28 days from a
Right.
prior violation.
Yeah.
Into the community. He was under close supervision, but had veered off the plan and left his employment to go somewhere else. And the thing is that he received a new 6-month jail sentence, which ends on March 28th. So I know he's given a 12-month sanction, but it's only 6 months after the end of his current sentence.
Mm-hmm.
And he's beginning to pile up a trail of victims here.
Exactly.
Stayaways that, it's just a public safety concern for me.
It is.
So I do have some additional questions I'd like to ask him and see if we can get to the bottom of where he's at now.
Yeah, I agree. It's just that before I can say that the sanction is will suffice, I really do need to know our information. And I did listen to the actual revocation hearing. And I just think that given his risk and the nature of this violation and despite his being in treatment, we should bring him
I'll
forward.
bring him back. I found the issues funny as well. So.
And just for the record, I was going to add a stay away from the Hobby Lobby. We can address that at the supplemental hearing. That wasn't on here, and there's some public safety concern here for me with this particular individual. Yeah, it really is.
Okay, so we're going to reject the hearing examiner's recommendation, and I'm sorry, off the hearing examiner Saunders when?
January 22nd.
January 22nd, 2026. Hearing will be, and our reasons are the nature and circumstance of the, and do we want to add his criminal history or what?
I think I'm fine with the nature of circumstances.
Okay. All right, so I move to reject the hearing examiner's recommendation with regard to Dylan Derosa 395251 and order a supplemental hearing, which will be held on January 22nd, 2026. There a second?
Second.
All in favor?
Aye.
This includes the final revocation for Dylan Derosa and 5251.
Thank God they rejected it and they're having a supplemental hearing. It's a special hearing where they will say, we need to actually see if we should give you more than a year or not. And we're about to watch this supplemental hearing, and it's with this board. It's like a parole hearing, but it's in the sense that the parole board will be there, but he will also have his state-sponsored attorney. If you can even imagine, just take a second and think about the cost that this man has put on the Connecticut taxpayer, the expense, the draw on society, all the many victims that he's created. And I can't believe it that that Rodriguez was actually going to be okay with 1 year sanction, which is only 6 months longer than the sentence he has to serve, right? You can't make this stuff up. It really is nuts. And then, thank God she said, well, I talked to our on-house psychiatrist, right, who's billing the state of Connecticut for that call, who knows how much. And, thank God the PhD in the room said, yes, this is all concerning. This is concerning someone who exposes himself. It's not good. And it's like, are you guys nuts? Do you not realize that this person checks all the boxes for the type of person, right? Well, let's see. Let's just see. Let's see how this supplemental hearing goes. I'll give you some warning in advance that you're going to want to pull your hair out. And I do want to ask you, please, if you haven't yet, please give Sir Richard a thank you in the comment section, because he's the one that's able to pull together all these hearings, connect all the dots, put it in a spreadsheet to make sure that I see it. And that's how I'm able to glue them all together and show you the process from beginning to end. Without Sir Richard, it would not be possible, not to mention all the research and everything that he puts into this. So please tell him thank you. And let's go jump in to the supplemental hearing.
I found that you violated the following conditions of parole: obedience to the law, specific domain laws, and problem-centered behavior treatment. I recommended that your parole be and you serve an approximate 1-year sanction with a re-parole date of September 30th, 2026. The panel determined that the following information could justify a longer period of incarceration. The board expressed concerns about Mr. Derosa's risk level, decision-making, the short period of time from his release and the commission of his new crime, and its inability to refrain from engaging in inappropriate sexual behaviors despite being under supervision and in treatment. Counsel and Mr. Derosa, this is your opportunity to respond to these concerns. I will now turn over the hearing to the chair and panel members.
Thank you. Officer Saunders, go ahead.
Yes, if I may, I know panel is going to have some questions from my client. Obviously, I have a copy of the summary you guys met, and then obviously I watched the hearing to kind of see what the concerns were. My first thing, when I did speak to my client on the 21st, he did not have the report yet. On the last page, it says a revocation hearing was held on January 6th of 2026, where Mr. Derosa, represented by Attorney Sarek, appeared before the hearing examiner Saunders. Mr. Derosa testified that he pled guilty under the Alfred Doctrine to avoid a lengthy period of incarceration. That was not our intention that was conveyed at the revocation hearing. A lengthy period of incarceration. What my client was charged with a singular charge. It was a breach of peace, which is a Class B misdemeanor. Max period of incarceration that is 6 months. When he resolved this case, he had been in for 3 months already. So, and the other reason why he had to plead, this is what happened. And I think it's important to get some background information as to what occurred prior to.
Let me stop you
Yes.
before you. So I think that to reduce the amount of typing that I had to do
Yes.
for the decision,
Yes.
when I said lengthy period of time, lengthy or period of incarceration, I understood, or we understood, if I'm correct, that because he was on special parole, he could have fought these charges, he couldn't bond out.
Correct.
We listened
Correct,
to
okay.
all of that.
Yeah, and I said, in representing my client, want to make sure that it's crystal clear, because this is what occurred. First time I spoke to my client regarding these charges, I'm going to hire my own lawyer because I want a trial on this, which he has a constitutional right to do. But goes to court a couple of times. They reviewed the police report, the evidence. It took a few months to get to that. And my client and his attorney in court came to the conclusion, we want a trial on this. So obviously the defense attorney has to tell the prosecutor, my client wants to go to trial this. And the response was, yeah, he can have a trial. It's a Class B misdemeanor. He's going to be sitting another 12 to 15 months prior to you getting on a trial. So he had to have a discussion with his attorney. What do I do? There's a plea in court. I'm not disputing that by any stretch of the imagination. The other thing I want to bring to your attention is to why my client had requested a trial from the get-go. In the East Haven Police Department, as we all know, I know you guys understand the process. At the preliminary hearing, we have a probable cause. At the revocation, we have preponderance of the evidence. And in criminal court, we have the highest level, which is proved beyond a reasonable doubt. I know you all know that. But in the Exhibit F presented by the state, I believe, once again, it's on the last page. There's a couple of things that my client went over with his attorney in court that to get to the level of proof beyond a reasonable doubt. The alleged victim in this matter apparently videoed with a phone, videoed my client and showed it to the police. And thankfully, this is from the police officer, not my client, but this is police officer. It should be noted, at no time did I see the male motioning his hand within his pocket from the video Shannon showing. One. The second thing I want to bring to your attention is the next paragraph where they actually went to the store and they went to the security IT people who ran the video surveillance camera, and the individual indicated there were plenty of blind spots. They see a person with his hands in his pocket, but they can't tell what he's doing. That's not a crime. So that's want to give you a reason as to why my client had asked for the trial and what led to the plea. And I know there was some question from the panel regarding that. And the other thing, that after reading this and reading watching the hearing, regarding the treatment part of it. I know you're gonna be asking him directly, which I do want you, I do want you.
Yes.
This is from Exhibit H, which is October 3rd of 2025, so it's not old, it's relatively new. The treatment response, file review indicates Mr. Derosa participated in his first treatment session for episode of 9/18/25. He attended consistently and engaged in treatment sessions. As far as credibility assessment information, my client in 2024, they gave him a full sexual history polygraph examination. He was found credible. So he is engaging in treatment. He's doing what he's supposed to be doing. This is the last one I want to bring to your attention is the discharge unsuccessful. Well, is stated as unsuccessfully, he was removed because of the arrest, which I understand that, but as stated, it seems like my got kicked out for non-compliance. That's the way I interpret it. That's not the case. I'm aware you guys read all the documents like I do, but that's what was going on. And it appears Mr. Derosa may be re-referred. So obviously, if he was doing what he was supposed to be doing, took the polygraph, it's not like treatment facility said, you know, he's not doing anything. We want him kicked out. He's back in the community. And I think those were the points that I did speak to my client about. And I believe there was one other mention regarding the time that the hearing examiner gave my client. As I indicated, the max sentence on a Class B misdemeanor is 6 months. The hearing examiner, doubled his sanction from my perspective that my client, 6 months jail time, and then she gave him an additional 6 months for a 12-month period incarceration with the understanding, I have the paperwork here, my client was out 28 days. When this incident occurred, he was going to work, and you can have him explain it further if need be. He had his work shirt on. Bus came early, he went to Hobby Lobby, and then he was working at Chili's, which was walking distance. So he was working, he was out September 2nd, so within 20, he got a job. So I wanted to just make clear that record and whatever questions the panel may have of Mr. Derosa.
I appreciate that. Thank you, Attorney. So, Mr. Derosa, is there anything that you would like to add, or in addition to what your attorney has provided us before we start our question period?
The only thing I'd like to add is, truly, I understand I was only out 28 days. However, as my attorney pointed out, I pled under the Alford Doctrine. I've maintained my innocence from the beginning. I did that because, as you said, I would have been spending possibly 18 months on a 6-month sentence just fighting the case. The mistake I made was when the bus brought me there early, I should have just waited at work. I made the mistake of going to Hobby Lobby and walking around to kill time. Had I never done that, I would never been in the position to be accused in the first place, regardless of the fact that I'm innocent. And I understand that, but that 28-day thing, I do want to preface that with the fact that I have maintained my innocence the entire time, and people are not always guilty of everything they're accused of. I did plead that. I do not dispute that. I pled out. I did, but I did it under the Alfred, and that 28 days I do think should have that caveat that it was an arrest that should never have occurred. And had I not gone to Hobby Lobby, it never would have occurred. And for that, I am sorry, but I do still dispute the facts of the case, and that I think that should be taken into account with the 28-day factor, because it's that's all I really have to say.
Thank you very much, Mr. Derosa. So I just want to make it perfectly clear that we have reviewed your file extensively, and we do appreciate all the information that you have and we did review your revocation hearing with hearing examiner Danelle Saunders. But we understand that our concern is regarding your instant offense and the nature of the violation, but even more so the behaviors which is what brings you here today before us. So one of my questions that I did want to ask is our understanding that the hearing examiner is not able to ask you questions and not able to build a case for the state or for you.
So, and with that, when I listened to the hearing, I'm like, why didn't she ask? Why didn't she say this? Or, so that's why you're here, because I'm just
Okay.
like, I wanted to know why you were at the Hobby Lobby. You've answered that. However, and I also wanted to know under what premise you wanted to take your case to court, which you told us today too. You were innocent. So now I want to ask you about your treatment and some of your lack of usage of the tools that you gained in your treatment. Okay. So have you ever successfully completed the problem sex behavior program?
I completed the phase 1 section of it in the January Center. I did complete that successfully and was discharged back to the community after a 3-month period of successful completion. As for the phase 2 section, I have not successfully completed it. Unfortunately, that has been due to rearrest, and there's no excuse for my rearrests in the past. I've served my time for those, and you're right. I was not previously utilizing those tools that I gained. I re-entered treatment with every intention of doing so. And I just, unfortunately, because of the circumstances, was unable to spend very long in the community to show that I am willing to utilize those tools and I'm willing to work. I've never bucked against treatment. I've never refused to go or to learn from my mistakes. I am utilizing the treatment as best as I am physically possible doing so. I admit readily when I am wrong, and I ask them for the help that they can offer me to give me those tools to use in the community. When I was released this last time, I was ready to do everything right. And due to circumstances, like I said, I was unable to show that growth. I was only able to return to treatment for 1 session before this incident occurred. So I did not get a chance to prove myself.
Mm-hmm. Okay. All right. So the real answer to my question was no. You only completed certain facets of the program, not the entire program.
Yes.
So my next question is, are you aware of the fact that you're considered a high risk to recidivate with new sexual offenses?
I was under the impression I was at low, moderate risk, not low, sorry, moderate, but I do see how that might have been raised to high after the last offense. So that's I can see that.
And that's what my next question was going to be. Why do you think that is?
Because of my reincarcerations, I would say is the most likely reason that it was raised from moderate to high risk.
Because of the behaviors that you've been displaying in the commission of those offenses.
Correct. That's correct.
And are you aware or did you sign the conditions of your release, Mr. Derosa?
Yes, I did.
Okay. And is there any so you were aware of the fact that you were prohibited from entering into entities where children frequent and all that stuff? You were aware?
Yeah, yes.
Okay. So then why did you go into the Hobby Lobby?
I would like to say that I didn't think the Hobby Lobby was a place that children would frequent. I thought it was just there's a craft store. I'm a person who enjoys art. I had an hour to kill before work, and it was one of 2 stores in the parking lot with the Chili's. I didn't want to divert too far from my work. I just wanted to kill some time. That is why I went there. I walked around. I looked at some supplies, some craft supplies. Like I said, I'm an artist. I enjoy writing. I enjoy drawing and painting. I was just that's literally all I was doing, was just window shopping. I also went to the TJ Maxx there as well. I was not just like I only went to the Hobby Lobby. They're just the only 2 stores in the area.
Right, but I know that the conditions of your release specifically say that you're not allowed to deter from wherever you signed out to go, which was work on this day. You're not to deter from. Go ahead.
Yeah, no, that's correct. Which is why I didn't leave the parking lot. They're in the same parking lot. I understand now that just entering that's why I said that is the mistake that I made. I should not have entered that building in the first place. In my mind at the time, I was saying, all right, I'm not leaving the premises of work. I'm in the area. I'm not going and gallivanting off in random places. I understand where that thought distortion is now, that just entering the lobby was diverting from that pass. And even though there was not a finding made on that diversion factor, I still do understand that had I not gone there, I would never have been in this position in the first place.
Exactly. Even though there wasn't a finding made, I don't think that the officer, your supervising officer, even brought that to the attention. I mean, to the officer's attention. Like that wasn't one of the counts that they were considering.
That's correct. Well, that's correct. Like I said, but I do understand that had I not been there, it would not have been this whole issue would not have been an issue in the first place. I do accept responsibility for that. Had I not been there, I could never have been in a position to be accused.
So, and I'm just going to go back to your statement regarding you're entering into a craft store. While I know a lot of adults do like to do crafty things, I don't have time for crafty things, but that doesn't mean that other adults don't. But most of the time, arts and crafts and stuff like that usually are for children. Do you agree with that statement?
I don't. I'm sorry, I don't agree with that statement. It's a store for adults. They might shop for their children there, but I don't think that anyone brings their kids to the. I understand that now, but I wasn't viewing it as a place that minors frequented. Like I didn't think of it as like a park or a beach or the mall or something like that. It was just a store. I wasn't thinking in the sense of, oh, minors are going to congregate in a Hobby Lobby. That was not my thought process.
So do you deny walking around the store with your hands in your pocket?
No, I don't. I had my hands in my pockets.
Okay. Were you fondling yourself? Were you touching your penis at any time?
I was not at any time doing that.
Were you sexually aroused at any time?
I was not.
Because when reading the police report, it said that when the officer asked you that specific question, you said you weren't sure. So now your position.
There's a body cam footage of exactly what I said, which I would be happy for anyone to review and refer to, because I did not say that. I said at no time did I have an erection.
So do you? I know that this is a hypothetical, but as sworn officers of the law, I don't believe that they would add in information that they did not hear.
So perhaps I'm misremembering. I mean, it's possible that I said I don't believe I would have ever said that I didn't know, because I did not at any time have an erection, and I was also very flustered at the time. I'd been arrested for something that I was not guilty of. I was being asked a lot of questions. I was just trying to prove my innocence. If I at no point did I have an erection while I was there, and I can say that with absolute certainty.
Okay. So were you behaving in any kind of manner that would have been offensive to anyone looking?
No, ma'am.
Okay. Right. Because I think that I'm struggling with why this victim who doesn't know you, did you know this victim? Did you know her?
I never saw the victim. I don't know the victim's name. I was never, given the right to I didn't go to trial, so I didn't get to see my accuser. I was never informed. I don't know if I know the person or not. I honestly have no idea.
So, is there any reason to believe that she was aware of the kind of, that you were a convicted felon?
It's quite frankly, I've been all over the news since I was young. As you stated, I've been arrested many times. It is entirely possible that she recognized me through those things. I'm not saying she did. I can't speak to another person's motives. It is entirely possible that I was recognized from the several news articles and that I've been placed in, and the TV has put me on multiple times as well.
So when you were out in the community this last time, were you experiencing any urges or any kind of triggers related to your sexual deviant behaviors?
I was not. I'd only been home a short period of time. I was medicated. I was attending treatment. I was attending psycho treatment as well. I was getting ready to enter into drug treatment. I'd been home less than a month. I was working every day. I was at a halfway house. I had not had any urges to reoffend. I had not had any desire to reoffend. I just wanted to go to work and I'm ready to get my life back on track. And that's what I was working towards when I came home this time. As I said, I was ready to use the tools that they've been putting in my toolbox since I started this process a long time ago. And so the short answer is no. No, I had no desires to reoffend and no triggers.
Okay, so explain to us what are some of the tools that you gained to avoid these behaviors in the future?
Sure. Coping mechanisms that they've taught me have been very helpful to me. The number one that I use is ACE, avoid, cope, escape. Avoid situations if at all possible. If you cannot avoid them, cope with them as best as possible until you're able to escape from that situation. I also use thought broadcasting, which is if you have a negative thought or a trigger, to pretend everyone around you can hear your thoughts. because the more likely you're more likely than to, if everyone around you can hear the negative thoughts you're having, you're less likely to have them because you become embarrassed by them. I also use stop flip, which is when you start having a trigger or you get into a situation that may be risky, you picture a stop sign and then flip the situation in your mind. Stop thinking that and change your thought process. Those are the three that I use most. There are others as well, but avoid cope escape is, I think, the most effective. And unfortunately, I did not avoid the situation this time of being in the Hobby Lobby, which is and I recognize that. I do.
And do you find that certain places are triggering for you or certain situations?
I mean, I do have triggers, of course. And yes, certain situations, risky situations do trigger me. Drug use is a major factor in my triggers. When I'm using stimulants, I'm not in control of my triggers at all. I don't think my situations through. I become incredibly impulsive, which is why I was going to go to an IOP while I was out there, and why I entered inpatient drug treatment while I was here. I'm now in tier 4 here, trying to work on those as well. That's my biggest trigger for my offenses is drug use, truly. And yeah, obviously if I'm surrounded by situations that again, it's the drug use. It's the drug use causes me to do things. I can be in a situation where I'm surrounded by people and not have a trigger, but if I'm surrounded by people and I'm high, I might be triggered.
So I think that impulsivity also plays a significant role in your offenses, which is why the behaviors are so concerning. You know, had you not had this history that you've had, I don't think that any of us would really be here. You know, it's not against the law to be in the Hobby Lobby, but because of the risk that you pose to the public and because you have so many victims along the way, the behaviors, you're putting yourself in a situation where you could potentially, incur additional victims is what's concerning.
I understand that.
The fact also that you haven't been engaging in treatment for such a lengthy period of time, yet you continue to put yourself in situations where you could potentially be, have another victim. Like, I mean, it's like a revolving door almost. It's like exactly what it is that you should be doing, but yet you still find it difficult to do the right thing. And because of that heightens your risk, in my opinion. So I think I have one or two more questions, and I appreciate the discussion thus far. Do you accept responsibility for anything aside from not having permission to be inside that store?
As I said, had I never been there, I take responsibility for going to the Hobby Lobby. I do not take responsibility for what I was accused of. I truly was innocent this time, and I've admitted guilt in all of my previous things in treatment. And this is the first time I really said I need to go to trial. I understand the way my history looks, and it's probably very difficult for you to take me at my word at that. But this is the first time I'm truly saying, no, I am innocent of this. And so I accept responsibility for being in the situation in the first place, but that's as far as my responsibility goes in that matter.
Okay. And my last question is, how do you avoid putting yourself in these situations in the future?
By avoiding them to begin with. Just don't, if I'm at work and I have to be there an hour early because the bus gets me there an hour early, don't go window shopping. Go sit and work and stay there and wait for work to start. And that's what I should have did in the first place, and that's what I will do in the future, because God forbid I cannot be in a situation where I'm accused because of my track record. Even if I am innocent, I'm not going to be viewed as such. And I need to avoid any situation where I can be placing myself or others in harm's way in any way, shape, or form. So from now on, if I'm in a situation where I get somewhere I'm supposed to be early, I won't walk around. I won't spend time window shopping. I won't, do what I viewed at that time as what a normal person would do in that situation. I have to realize I'm not a normal person. I don't have normal situations. I have to be able to think that through, and I will in the future. I will go and I will sit at work and I will wait for that hour to pass, and then I'll start my shift.
All right. Thank you. Mr. Sebastian.
Thank you, Madam Chair. Good morning, sir.
Good morning.
So my colleague has asked most of the questions that I wanted to ask. So I just wanted to follow up with you on something that you said. And you talked about stimulants, substance abuse being your biggest trigger.
Yes, sir.
During that 28-day period that you were out in the community leading up to this offense, had you been using illegal substances or stimulants?
No, sir. I actually was clean the entire time I was home. I was properly medicated as well through my psychiatrist, and I was getting ready to start the IOP drug treatment as well.
Okay. I'm concerned and troubled, like my colleague said, about your inability to refrain from engaging in this type of behavior, given the fact that you're under treatment and supervision. So I don't know what more besides those things that we could do to avoid these kinds of things from happening, What else do you need when you're in the community so that this doesn't happen? You're under like the highest level of supervision. They were giving you very clear directions on where you could and could not go, and then you strayed away from that.
Even the GPS, I'm sorry.
Yeah, and I understand you maintain your innocence, sir, and everything, but the fact remains that we have the police report and you're convicted of this crime. So, that's what we have to deal with. You know what I mean?
I understand that.
And you're well within your right to maintain your innocence and all that stuff, but we have to look at the facts in the police report. You pled guilty to this. I understand it's under the Alfred Doctrine, but it's what we have in front of us. And the police report tells a different story about what happened from what you're saying.
The police report, like I said, the police report does say that it has the victim's side of it, but it also does include that the police officer saw nothing on the video. It also includes that, it does have that. And I understand what you're saying. As for what else, I need to remain clean, sir. That is the number one thing. And I'm working towards that. I haven't been able to maintain drug treatment in the world at all. And that is the number one thing I need to maintain. I came here to jail. I didn't allow that to derail my thoughts of getting treatment. I immediately enrolled myself in Tier 4, which is a highly intensive inpatient drug program in jail. And I need that because I know that when I go home, I cannot use because it will lead to more offenses. And that is the number one thing I need to fix. It's also helping me with my impulsivity because the impulsivity is partially what leads to my drug use. So by working on that impulsivity, I can prevent both my reoffending and my reusing. As for what more you guys can give me, I know you give me the highest level of supervision. I'm well aware as having been under it. I don't mind wearing a GPS. Even after I get out of the halfway house, even after the normal 3-month section when a normal person might be let off, that I don't mind maintaining that level of supervision. I'm doing whatever, meeting with my parole officer multiple times a week if I have to. Whatever I need to do to show that I'm willing to take the steps to be different and to change, I'm willing to do it.
Okay. I appreciate all that. But you say you need substance abuse treatment. I get all that. But you say during this time leading up to this, you were not using substances,
That's correct.
And you, although you maintain your innocence in some of the facts of this, you do acknowledge that you went somewhere you weren't supposed to go. It kind of started this whole thing, right? That was the first wrong step.
I do. Like I said, it was not. In my mind, I was not doing. I understand completely what you said about it being a crap store with in relation to. But as I pointed out, that was not. It's not like I went there with the intention of going to Hobby Lobby to see children. I also went to the TJ Maxx. They're the only two stores that are there. It was not in my mind like, oh, there's going to be kids here. Let me go to Hobby Lobby. It was, this store is here. I'm just going to go window shopping. It was that, and I realized that I have to think even more. I have to think it through even more than that because I have to look at it and say, okay, could this be somewhere that could be considered a place where I'm going to run into kids and I can't, and like I said, just not even going there in the first place. And I realized that's something the situation has shown me because, as I said, I was doing something that I thought a normal person in that situation would do, but I realized I'm not a normal person. I'm not in a normal situation. So I can't act on just saying, well, this is what everyone else would do, so it's okay for me too, because it's not. And I do recognize that now.
I appreciate that recognition. I wish you would recognize those things before.
As do I.
You know what I mean? Because we wouldn't be in that situation. You know what I mean? If you just went from where you're supposed to be to where you're supposed to go and back and just keep doing that, you would have been fine. But here we are today.
Right.
It resulted in a conviction. And this.
Absolutely right. And I can't dispute that fact.
Yeah. Okay. All right, Madam Chair, that's all I have. Thank you for answering my question, sir.
Thank you.
You guys, both of you covered most of the questions I would have had already. And I think you said it. Your impulsivity is something that really needs to be dealt with and worked on. That's what got you here. You didn't think this out. You're right.
You're exactly right. I didn't think it out. That's exactly right.
You didn't think it out. And you should, you're right. You should have probably gone right back to your job.
So,
Anyway, what I mean,
thank you, Mr. Rodriguez. I just have just one follow-up. In our, in the written decision, we referenced your being re-released after you were released from prison originally. And that was for another breach of peace. Is that right?
That's correct.
Was impulsivity involved in that as well?
It was. I was at that time I was engaging in substance abuse. And I was with another person I should not have been around, and it did in fact lead to an impulsive decision. It was a spur of the moment impulsive decision as well, and I accepted full responsibility for that.
All right, so we're done.
I do have one.
Okay, go ahead.
On you're currently in tier 4, right?
Yes.
I am.
Yeah. So at what point in tier 4 are you?
I'm about to complete phase 1.
I think.
Thank you. Attorney, that's. Do you want to make any closing remarks?
No, I hopefully after the panel's heard from my client, my opinion, the 12 months was a substantial sanction, given what the breach of peace, the 6 months, as I indicated. I understand, and I think my client has been saying it better than I. Unfortunately, because of his underlying conviction, he does carry a stigma. I agree to disagree, but you guys have a diverse background. Those facts are the facts of the case. I understand he pled, and he admitted he pled. But for that parole status, I was in the GA for 18 years. I would love that set of facts to put in front of a jury, because it's proof beyond a reasonable doubt. I understand what the police officer said, but I also have a police officer that indicated he didn't see anything. There's nothing on the other video. It is a very tribal case. In my opinion, 6 reasonable people are not going to find it proof beyond a reasonable doubt. It's just not in that report. But he did plead. We admit he pled. So I am asking you to consider to maintain the 12-month sanction, which in my opinion, as I previously said, giving them the max on the breach of peace, which is 6 months and an additional 6 months. My client is on supervision until 2034.
Exactly.
Now, he's been back twice.
Right.
Comes back the 3rd time. I know what's going to happen. They're not going to have the same argument. Well, being engaged in trial. I understand that. And I was frank with Mr. Derosa because of the stigma he carries. But he did his time for those charges. We can all hopefully agree on that. But you can't, I agree with you guys, you can't come back with similar type of behavior, because you're going to flip his record and say, well, this happened. This is similar. This is similar. And he understands that. And the drug issue, which I wasn't aware was kind of the trigger for him, but he's dealing with that. He's in the Tier 4 program, which he started. He's working when he's out. And the treatment provider did indicate he does engage. He was truthful. If those things weren't present, I wouldn't be sitting here arguing on his behalf that 12 months is, it's not enough. But he is trying, failing at times, but he is trying. And I understand the concern, public safety part of things and all of that nature. But also at the end of the day, it was a breach of peace. The original bond was $75,000. When he went to court and the judge reviewed it, prosecutor reviewed, bail commission, it was over to $2,500. So I assuming they saw some of the same stuff I saw, otherwise they bond could have went up. It went from $75,000 to $2,500. Now, I'm not minimizing the victim's allegation, but when it goes to court, I understand we have a different standard here. That's why, in my opinion, I think the bond went from $75,000 to $2,500. I hoping, it doesn't go up. He's trying treatment. He was very forthcoming. He could have made up things up to answer your question. No, I was, yes, I was using it at the time, but it was an impulse. He admits he was not using it at the time. He shouldn't have went to the Hobby Lobby, as indicated. It was in the same plaza, but he knows he should have never walked into that store, because the 5 of us wouldn't be here today.
Exactly.
So I that's all I have to say. He's well spoken, obviously. And he's, once again, he's on supervision until 2034. So he's got to get on track or he's going to be spending.
A whole lot of time looking at me. You don't want to do that.
And he's out about 35, 36 roughly.
34 at the moment. I'm almost
34.
35. Yes, I'll be 35 in May.
Yes. So, and you have another 8 years of supervision. And I know at 34, you,
In his 40s.
yeah, you don't want to be spending,
No, sir.
thank you. I don't have anything else to add.
Thank you. So Attorney Sareka, I could argue a lot of things that you said, the direct opposite. Honestly, and I appreciate your advocating for your client. He is a very intelligent person. He is also very articulate, and I wish that he would utilize that intelligence for some more good. And while I can appreciate the video not showing him doing anything, and there is also in that police report, it says that there were certain blind spots in that store.
Correct.
And absolutely, he could have been doing something. I don't know that. And, I wasn't there. I've been to plenty Hobby Lobbies. I'm familiar with the area that he's referring to. I've never seen anybody walking around the store to pull out my camera and start recording something that somebody's doing for no reason. And I've been doing this job for a number of years. I don't know anything about his case aside from what I've reviewed. I've never seen him on TV or any of that. I have no biases against him. I just find it difficult to believe that someone would go to this length and be so offended without there being some kind of reason.
May I ask, Mike, were there any other people in the store, Dylan, at that time?
Absolutely.
Okay, and probably should have brought that up. Not one other person, if someone's walking around with their hands in their pocket masturbating or fondling themselves, no one else came forward. Yep, I agree with you. We don't know what happened.
Right.
But once again, in advocating for my client, I understand BOPP has a different standard. To get to proof beyond a reasonable doubt with the evidence in that police report, I don't think they can get there. Just
All right.
my opinion.
All right. So at this point, we are done speaking with you two. We're going to speak amongst ourselves and come up with what we believe is an appropriate sanction. And that we're very well may be that we agree with the hearing examiner, and we very well may not. So, Mr. Suzalskis, would you like to begin, or would you like me to? I've done a lot of talking, so. As you do.
Yeah, so, I am concerned for public safety. It's like we all mentioned, similar behavior to what we read. And we talked a lot about the police report and whether he's guilty or innocent of the crimes and how he went down and all of that. But in the end, he is guilty. I mean, he pled guilty. He understands the Alford doctrine. He was able to articulate and maintains his innocence. The police report does say, I understand there were some things in here that says that they did not see, but it does also say, the police officer says, that he looked at the video and it says the male appeared to have an erection from the video and that he had his hands in his pockets. So that part, according to the police report, what the police said. So if we're to believe what the other things the police officer said, I don't know why we wouldn't believe this, right? So we can't pick and choose what we're going to believe in this police report. It also says when they interviewed him after at the police station, when they read him his Miranda rights and asked him what happened, they asked him if he had an erection. He says, I don't remember. It's right in the police report. So along with the facts that we stipulate to that says that there are blind spots and no one in any of the videos or pictures show him moving his hand, but there are these other statements. And according to the person that made the complaint, they were upset and troubled by what they had saw disturbed. So it is concerning to me. He says that his triggers, he had different triggers, but his biggest trigger was substance abuse. So he said in previous situations that had led to him making impulsive decisions, but when asked if he was using substances before this impulsive decision, with at least we can acknowledge the part he admits to walking into the store, right?
Yes.
Right, so let's just deal with that.
Right, and he also
He
admitted
wasn't
that.
using substances, but he still did this, you
Yeah,
know?
but he also said that he was aware of the fact that he wasn't supposed to be doing it.
Yeah.
because based on the conditions that he signed.
And he's already under a high level of supervision. He's in treatment programs already. So I don't understand when he goes back out, what more are they going to do to prevent this from happening? So I am very concerned for public safety. I like hearing my colleagues have to say.
Yeah.
But there's just so many people that have been affected by all this.
I know.
You know, I don't want anyone else to have to experience any of this, what we're talking about.
So, and I agree with you, Mr. Suzowskis, you know, the fact that he is on special parole until 2034. In my experience, just being here for the length of time that I have, oftentimes when people like Mr. Derosa comes before a judge, the judge will say, well, look at the fact that he has, you know, till 2034 and pass it back to us to make the determination in terms of whether or not he deserves to be in prison a little longer than whatever the sentence was given. I know that we're trying to educate everyone now at this point that this is what happens, but the fact remains that you know the behavior is what is very concerning to me. So at this point for me, I'm happy of the fact that he's in the Tier 4 program. I would also like to see him participate in the problem sexual behavior treatment in the facility, even though that he may not receive the treatment again because he's already completed it in the facility. That may not happen. And I've also heard him talk about his mental health. So I would like to see all of those things addressed in a level of stability. It doesn't look like he has any trouble when he's in the prison. I don't see any disciplinary charges. I just can't for the life of me understand why he continues to participate in these kinds of things with all the supports that he has. And because of that uncertainty, I think that that's where the risk to public safety comes into play. So at this point, I'm leaning towards a lengthier period of incarceration. Mr. Rodriguez.
I mean, I basically share the same concerns. Instead of having to go all over it again. I mean, for me, the fact he does have his time still to 2034, does anything, gets back out again, he's coming right back in. It's going to be a much worse situation for him than it is now. Much worse. I mean, I think for me, today he's admitted his impulsivity, the fact he made a bad decision. I think he's come to grips with that, and I'm sure he can now feel the impact of all of that, and has been feeling the impact of all of that. The fact he's in Tier 4, I think is a very good thing for him. I definitely want to see him finish that. That's something I definitely want to see him finish. Yeah, I definitely want to see that happen. But I'm leaning toward accepting the hearing examiner's recommendation. It comes out in September. Gives them time to work on this program. It may give him some time to do some other things in there that we can look for him doing. And that's kind of where I'm being at this point.
Okay. All right.
And I understand both of your concerns about public safety.
Yeah.
You know, but it's got,
yeah.
For me, there are a variety of inconsistencies, not only in the police report related to him, but in the connection with the person who filmed this. And I have no idea what's going on with that either. We weren't there, we have no clue what's going on. I think his attorney made a good point of there are other people in the store. Nobody else said anything. Nobody else noticed anything that was going on. Just this one person.
I would argue.
I get it, but this is my perspective on this.
I get it.
This is my perspective on this. So, but yeah, I'm going to.
Okay.
So for me, like state my position, I want to hear from both, but you know, based on his high risk and the risk to public safety, I would be in favor of a longer sentence than what has been offered here.
So to add to everything that's been said, the fact that he's only been under supervision for what? A year? He was released originally. He was discharged to parole in January and came back And
January
so he was
24.
out there for a year.
January of 24. It's 2 years. January 24 to 26, January 26.
No, he was out, he was released as parole in 2024. He came back with a new violation in March,
Yeah,
and he
okay.
was in prison for 6 years, for 6 months, and then re-released in September.
Yeah, I got it. Sorry,
So, he's been in more than he's been out. I just 2 violations in less than a year. It's a lot. So honestly, I would, I'm not willing to do the 12 months. I would, at least do, he's done, I'm sorry, hearing examiner Saunders, in June of 2026 is when he EOSs on this new conviction.
2026.
Okay.
The state right now for the 1 year would be September 30th.
Yeah, I want to make sure that's clear. The sentence is March, but the sanction she gave is another 6 months on top of that which brought us to September.
Correct.
You would do another 4 months. 6 months. I had it on this.
Why did I write down 6/30? Why did I? Got that date from?
And sentence sentence.
She got 6 more.
March.
She got 6 more months now.
And the current offer of
No more.
penalty would go to September 30th, 2026.
That's got 6 months.
All right, so. We came back
And he's been there since when?
October 1st.
Huh?
September 30th, 2025.
Oh, he's been there.
Yes, this would be a 1 year total.
Okay, it would have been a year.
I would do, I honestly, I came in thinking 2 years. But I did want to talk to, 2 to 3 years, is what I said. I did want to talk to Mr. Derosa because I really did have a lot of concerns. And my main concern is how many more victims do we have to accumulate before we recognize that these behaviors are seem too much. That's me being me. So I am at 2 years right now, and my math is not mathing.
So you're talking about an additional year to what has been offered? So it'll go to September 30th, 2027.
No, I'm going from his return date that I have. And I know that this is what Attorney Sloan.
You're talking about another 6 months?
No, I have to think about what I'm trying to. March 2028 is the end of this sentence. So I could do March 2027.
Okay, so that would be an additional 6 months to what she's offered. She said 12 months, that would make it 18 months.
Okay. Is that okay?
I would be okay with that. I was concerned that 2 years might be too much, so I was, based on what, the way he presented today, he was articulate, and did say some good things, so. The extra 6 months, hopefully you can get tier 4 done. Maybe, maybe, I don't know if he's done voices before, but maybe he can do that. Problem sexual behavior treatment, if they'll allow him to take it. I think he might get a witness for all of those things, In 18 months, he should go, and then try to stay on track. I mean, he's got to do
And I
everything.
could just put an additional 6 months just to see me the program, because my concern is in getting the program.
Well, and in a safe environment, so like instead of in a community where he can't,
You can't make those decisions to go into.
I know it's not the same program that's offered in the facility.
Right.
The treatment program in the community is the inpatient. It's much more in depth and so forth. I get all that, but we've already tried that twice.
Right.
It's not.
Yeah, I wouldn't support any more, no more than months. That's it. I would support the addition.
All right. The only other thing that I had is that I wanted to add, stay away from the Hobby Lobby 68 Forest Road.
That's not a problem.
Yeah, yes.
He wasn't supposed to.
A lot of stores you got to stay away from.
I mean, I wouldn't.
No, he, and I think he's picked it, he knows.
He wasn't supposed to be here in the first place.
Yes.
So,
It's a good
Yeah.
point. Yeah.
That's why he violated, because, anyway. So in addition to those conditions, we have no victims, hearing examiner Saunders, MW, JK, no minors, halfway house if needed. I know his mother has agreed to act as a sponsor, right?
It's gonna be 18 months, so.
I will put it just in case he can. Mental health evaluation and treatment, problem sexual behavior, no Edward Bertie or Christopher Armstrong. Is that it? Did I say everything?
And general stay away from 135 C5 on Milford Bennett.
And what is that?
That was from his first violation.
Yeah.
Already confirmed.
That's why I was saying that, this other one, maybe, you know.
I don't understand. Was he supposed to be there?
That was a residence.
Yeah.
Okay, all right. So, with regard to Dylan DeRosa, 39525 going to move to revoke his special parole, which was already done, and have him re-released on March 28th, 2027. That is an approximate 18-month sanction, right?
March 28th, 2027 is a Sunday, Easter. That's what.
Okay. 20 is a Sunday, so the 29th, that's a Monday, right?
Correct.
Okay, so we'll do March 29th, 2027 with the following conditions in addition to the standard parole conditions. You are to, I didn't see no alcohol condition, was there one? You are to participate in problem sexual behavior treatment and mental health evaluation and treatment is deemed necessary, or have no contact with your victims. MW, I'll just do any positive programs. MW or JK, Edward Uberti or Christopher Armstrong, no minors, and a halfway house condition, just in case that's needed. You are to stay away from 135 Seaflower Road in Milford, Connecticut. Did I say everything? Is there a second to the motion?
Second.
All in favor?
Aye.
All right, so Mr. DeRosa, we went a little longer. What we would like you to do while you're there in the facility is advocate for yourself to get all the help that you need. We do not want you to fail out in the community. That's not our desire, sir. But we do have our main priority is to protect people in the public. So if you have all the tools in your basket that you need to learn now how to utilize all those things when you're back out so that we don't see you again. You are capable of doing it, sir. We need to see you do that, okay? It's really important. You have to make better decisions or else you're going to keep coming in and out. We don't want you doing life in installments.
Neither do I.
All right, good luck to you, sir. Thank you.
Dylan, I'll set up a call with you next week. I have hearings tomorrow.
So all of this, and it's a 1.5-year sanction. Keep in mind that he was sentenced to 6 months jail for this last offense. So it's really only a year because he gets his 2-for-1 special out of the state of Connecticut. And I think if you're like me, if you don't have a PhD, if you're not a parole board member, you probably found yourself screaming at the screen because what the hell is wrong with these parole board members? I for the little respect I had for Rodriguez, because I thought he was like kind of on the better side of the Connecticut parole board thing. It's just all gone. I mean, listening to what he was saying, the whole parole board, what they were saying, they kept agreeing with him, with the Chomo. They kept saying, yeah, your only mistake was going to Hobby Lobby. You know, if you hadn't gone to Hobby Lobby, we wouldn't be here in the first place. He's like, yeah, I shouldn't have gone to Hobby Lobby. And they're like, yeah, don't you learn you can't go to Hobby Lobby? And it's like, what? No, his mistake was going around the store doing the thing. What are you guys talking about? How do you not believe that that's what happened? How could there was no reason? His attorney's like, well, if I was in front of a jury and there would never be reasonable doubt. It's like, no, I don't know. You know what? If the judge allowed all of his previous record to be shown, and I don't know how a judge would roll on that, I'm pretty sure a jury would find him unanimously guilty. Like, no, I don't think that this one girl just made it up. And they're like, the whole idea of it is asinine. It's nothing short of insane. And they're going with it. They're like, yeah, maybe it happened. Maybe it didn't happen. There was only one person who complained about it. The cameras couldn't exactly see. It's like, what are you guys talking about? And if you've seen parole hearings in other states, had this happen in Louisiana, for example, they would have laughed at him. They would have just revoked him. They wouldn't bought 1 second that what he's saying is true. Of course he's guilty of what he's accused of doing. Of course he is. But they're not even bringing that up. They're actually like, nope, the only mistake you made was going into Hobby Lobby. Further on, Rodriguez goes on to say that, I think you did great in this meeting. He was very articulate. And it's like, you're articulate? You're not in prison for because you butchered grammar. You're in prison because you're a chomo. They're like, I don't know. He doesn't have any problems in the facility. It's like, well, there are 13-year-old girls in the facility. It really, you see this, you see it, and you just want to scream. You need to say, how is it possible? How is it possible that those placed in charge of protecting us are so utterly incompetent? This is incompetency. It's insane. You would think it's a dereliction of duty. What are we even having a conversation for here? He is a serial offender. He can't help himself. Of course he's doing it. And you should have punished him more for not admitting it. What are you giving him any benefit because he pled under the Alfred plea? Call him out on that. Say that's BS. Say the DA did it because they wanted us, the parole board, to handle it. Look at the facts. They were all laid out on a silver platter for him. They had the police reports. They have the body cam footage. They have him even admitting at intake where he's like, I may have had one. No. The victim made it up. She recognized him from a news report and said, I'm going to call the cops. I'm going to wreck my day. That's exactly what happened. Right? The serial offender who has done this over and over and over and over again. And you are literally going to sit here and say, yeah, the biggest mistake he did was go into the Hobby Lobby. Yeah, maybe he didn't do it. Oh, this is kind of weird to me, Rodriguez says. That this would happen. What? Do you not take one moment to look at this man's track record? This is what he does. Had this been like the Louisiana Parole Board, they would have said, you're a liar. We don't believe you. Had this been anybody with common sense, they needed to drill into him that you are lying. You can't get one over on us. I don't care that you pled the Alfred doctrine. I know what you did. And until you can even admit that that's what you did, you can't even begin to get better. And it was like he was able to just lie. And they said, yeah, that's right. Yeah, you haven't been doing anything wrong. You just went into the Hobby Lobby. That was your mistake. You can't go into the Hobby Lobby. You can't go to Chuck E. Cheese, right? You can't go to Target. Yeah, I wonder why he was there. I wonder if it was to look in the little kid section. The guy is his brain is wired differently. He's obsessed. Like, you watch enough of like Alex Rosen and any of those other quality and you see this character every day in their predator catching every day. He is just like he fits in the box perfectly. And to imagine too, the it's like it is incredible. You need someone like Alex to interview to get him in the process and get him because this guy would just open up and confess to everything he's done. And what's crazy to me, in the police, they just do the report and they just there's it's like But what's crazy to me is that he doesn't have anything on his record for downloaded CP, like, on his phone. And it just makes me wonder, like, how is it possible that they never got you when they went into his home after he essayed someone and they found the gun, did they not check his devices? Like, did they not get a warrant to check his devices, or did they not think about it? Because I find it impossible to believe, and this is just my opinion, that he wouldn't have had content on his devices. He can't help himself. He has zero impulse control. He is a repeat multi-build offender with a long track record. And I am so happy that we were able to see this from beginning to end through the entire process. So I mean, the only thing we're missing is initial parole hearing, which is a shame. I wish that we could have had it before we started covering it. That would have completed the dots. But that you see it through the entire process, right? He gets paroled. He immediately is busted soliciting a minor. The agenda-driven judge, DA, they drop it. They drop it to disturbance of the peace or whatever and give him like 30 days. Then he's out for like less than a month when he's catches doing something else, and they give him 6 months, the Alfred plea. But they drop it again to another misdemeanor. So, like, on his official record, those don't show up as sex offenses, but they were. And what if that girl had taken the $20? Like, then what? Like, he literally is dangerous. He is so vile. He's one of the more dangerous S offenders that we probably have covered, because he has zero impulse control. He's being coddled. He's being coddled by the system, being coddled by his mother. He's being coddled by everybody. And what's going to happen when he gets out in a year and a half? The question is how, is he just going to throw his hands up and say, yeah, maybe we'll just go all for it? Like, he's just creating more victims wherever he goes. And these are only the amount of times that he's caught. I mean, let's again go over how crazy this is. Like, this is the news article. Sex offender followed woman in East Haven store while committing lewd act. This was October 1st, 2025. This is what the police say. This is just a few months before the hearing we just saw. And he was charged with engaging in lewd acts inside a store while following a woman. And this is what the parole board saying, well, maybe it's not true. A registered offender is facing charges after he was following a woman around a store while master debating, according to police. Dylan Alexander, 34, of New Haven, was on parole at the time of the incident Tuesday, police said, and was taken into custody. Police said Derosa was located inside the same plaza where the offense occurred at his place of employment when he was apprehended. Officers were dispatched to the Hobby Lobby store in East Front. It's so comical, Hobby Lobby, after complaints that a male suspect was following a woman around the store while appearing to do that underneath his clothes. And he's like, Hobby Lobby is all not for children. And they're like, yeah, well, I don't do Hobby Lobby stuff. But it's like they were all gaslighting themselves. It was like they fell for his gaslighting and then fell into this rabbit hole of, yep, the only mistake you made was going to Hobby Lobby. It's like, what are you guys talking about? It should be noted that we're deeply disturbed by the behavior alleged in this case. Police said women should never have to fear about being followed and subjected to predatory conduct while simply shopping in a store. No one should ever feel unsafe in our community. And now this was, I guess, what the police officer said. But they are made to feel unsafe in your community because you continue to release them time and time again. Police said he was charged with second-degree breach of peace and was held in lieu of $75,000 bond. He was being held on a parole remand and was scheduled to appear in court Wednesday. This is a perfect example. It's a poster example for just how broken the system is. He has a long record going back every moment that he's out. He commits an SA. He gets like a year sentence. While he's on bond for that, he commits more crimes against lewd this and doing that in the parks. Then when he gets out on parole, he immediately commits another essay and has the gun charge, and then has like 2 more lewd acts thrown in the mix. Then he finally gets out on parole for a second time. And in that short period of time, he literally solicits a 13-year-old girl. He says, here's $20. And what do? The DA says, we'll give you 30 days jail. And the parole board says 6-month sanction. What? For a crime like that, soliciting 20? Are you kidding me? And then when he's out for just 27 days after that sanction, he commits this crime, and the DA lets him plead down again to 6 months jail. It's right here, right? Look at his long record. He has essay released, and he gets, like, let's just hear 5/28/2014. He has all these public indecencies, risk of injuries, right? He has the criminal possession of firearm. He has essay first degree, where he gets the 90 months, but he gets out early on parole. Then he has the breach of peace. This is soliciting a 13-year-old, right? When he's driving around with another S offender. Can you even imagine? And then he gets this pled down, where he gets 6 months for the Hobby Lobby incident. And it runs concurrent with this parole. So whenever the parole board tells you, and they tell us, they lie to us, they tell victims, we should just release them on special parole. So remember, if they mess up, they will come back, they'll do all their time. No, they don't. What more does he need to do to be said, you know what, you're done, you're just going to prison? You have the DA and the judge saying, don't worry, we don't want to go through the whole court. It's a headache. Let the parole board handle it. And the parole board does nothing. You cannot look at this as a reasonable person. I forget unless you have a PhD or you work in the parole board. I do not think that there's anybody that would see this and say this is how things should be handled. There's no one that's watching this and said, yeah, this is textbook. This is textbook for keeping our community safe. It's like there was a hearing out of Louisiana where Miss Bonnie Jackson, I wish I could remember which one. I want to insert it, clip it here, but she's talking to someone who does the exposing thing, and she says, and she's like, people like you with your type of crimes, they're not like, and she, I'm quoting, I'm paraphrasing, but she goes on to say, it's a different level. It's a different type of crime. It's like it's a different type of danger, and the impulsiveness and the type of profile of the person who does these crimes. And because of that, we can't release you. And she said it so, elegantly, but it's like she knows what everyone knows. This is a thing. But this parole board doesn't know that. They don't know someone like this is always going to be a danger. They have proven that they're always going to be a danger. Those who expose themselves, they're not like other offenders. They're made up differently. His special parole goes until 2034. Why would you not have just revoked him? At least a 5-year sanction. Let him. Obviously, he's learned nothing. Obviously, he needs more time. Obviously, he needs to take up some more programs. And, they're so two-faced. Like, if you believe that the programs work, then make him do them again. Put him in long enough to do them again. If you don't believe they work, we don't believe it works, it wouldn't make a difference. But they do. They are drunk on the Kool-Aid. They believe the program. So why wouldn't they say make him do it again? Because they don't get it. It's so strange. And listening to the parole board say what they were saying, it's just you want to scream. You want to scream. I don't know how his attorney sleeps at night. I guess it's his job, but I just don't know. You wouldn't believe it if you didn't see it, and that's what we do. What is so frustrating about this, and I believe I'm only saying what everyone is thinking, which is why people who like to hear the unpacking it's like therapeutic, right? I couldn't watch these without having the opportunity to vent and then read your comments on how like, yeah, I agree. I'm thinking the same thing. This is insane. Because it's therapeutic. Otherwise, you just sit here and you're left screaming like, this is so dumb. How do we live in a world that decision makers put in charge of protecting us are so incompetent? It's shocking. This is shocking. This entire sequence is nothing short of shocking. And we actually have many more hearings like this. The revocation, it's a lot of work. It's hard to connect the dots. It's hard to do the thing and the editing and the whole thing. So if you want to see more of them, they're in the return of playlist. But also please let me know in the comment section. And with that, I'll let you go.
Oftentimes when people like Mr. Derosa comes before a judge, the judge will say, well, look at the fact that he has, till 2034 and pass it back to us to make the determination in terms of whether or not he deserves to be in prison a little longer than whatever the sentence was given. I know that we're trying to educate everyone now at this point that this is what happens, but a lot of concerns. And my main concern is how many more victims do we have to accumulate before we recognize that these behaviors